What's up, everybody? It's me, Tom Howard. You can find me here or at CannabisIndustryLawyer.com. And if you want to get notice of when these go live, there is our QR code. Sign up for our newsletter. Today, we're talking about what's going on with cannabis rescheduling. It has been exactly 2 months to the day since Donald Trump issued his executive order calling on his attorney general to comply with the Controlled Substances Act as expeditiously as possible and finish rescheduling. Where are we on that? We have a presentation for you. And before we get into it, I'm asking for you to like this video and subscribe to the channel if you haven't already. Now, let's get into it. We did a presentation about this about a month ago. What has changed since then? Practically nothing has changed since then. There has been no movement on the appeal or on the rescheduling. There's rumors. That's it. We're going to go over why this will probably take longer than most people think. Matt Gaetz has been doing the rumor mill and sent out a tweet, 3 weeks ago now, and still nothing has happened. And in our docket, that nothing has happened. The administrative law judge has retired, so I don't even know if there is an administrative law judge that they could resume the hearing, provided that the interlocutory appeal, which should be before the DEA administrator, Mr. Cole, no movement on that. So not moving too expeditious. We just did a post about Sam, and is the smart approaches for marijuana, perhaps funding a lot of prohibitionist media that you're seeing on X and the other platforms. They hired Mr. Barr right there over at his law firm, Torrid Law, and they've already paid him over $300,000. So he's just ready, and he's been paid, monitoring the situation, poised to strike, and ready to file his appeal after the final administrative rule is in effect. Of course, we also have talked about the Congressional Review Act. We think that this will be a major rule because it impacts hundreds of thousands of employees and tens of billions of dollars. We don't think it's going to be, in our opinion, we'd be wrong. That's one of the things that I want to stress right now. The administration could issue this rule tomorrow, and I wouldn't be surprised. They could follow all the rules and try to comply with all the strictures of the CSA to suppress the appeal risk, because the appeal is coming. You don't just take $300,000 and not file an action. It's premature because we don't have a rule or not yet. Either way, the administration in power likes to do things their own way, despite what the rules may say. And as a result, they could just drop the rule, even though they might run afoul of certain things. For example, the Attorney General has delegated this authority under the delegation of authority, that's the federal rules right there, CFR, to the DEA administrator. So the Attorney General shouldn't be signing the final rule herself, and there's some arguments on that. We'll probably dig into that more, as I think we're going to be waiting for a while. I don't think that we're going to get Schedule 3. Could be wrong, but I don't think we're going to get Schedule 3 anytime soon. Now, this is where we are in the process. This started back in 22 with Biden directing the HHS to start doing the science. They did the science. That was in 23. They published the proposed rule in 24. They did the public comment period in 24. Tried to sit the ALJ hearing. That's getting into January of 25. That's when the interlocutory appeal blew up, and we've been stuck there. So we're trying to get the ALJ hearing wrapped up, get his report, and then send that over to the DEA, who would publish the final rule and make it more bulletproof for the appeal process. This is the particular statute that we are looking at. So what's this mean? Well, we have the HHS as a shield maneuver under 21 USC 811B. HHS does the medical and scientific review, and those medical and scientific findings are binding on DAA. DA doesn't relitigate the science like it's courtroom drama or anything. It's over. So the argument is, if the only remaining disputes are medically and scientifically, there's nothing meaningful for a DEA hearing to decide, because the DEA can't legally contradict HHS on those points. Then the tactic is pretty straightforward: deny or cancel the hearing on the ground that no legally relevant factual issues remain, because the science is already locked in by HHS. So if the record says the science is settled, you try to make the hearing unnecessary and move straight to the final rule. It could happen. And if it does happen, it'll look something like summary disposition, which is basically like a summary judgment, but inside an agency. The DOJ's move now might be to say, look, nobody's disputing the key scientific facts. What the opponents are doing are arguing policy. Policy arguments don't require witnesses and cross examination. We don't need a live hearing for them. And so the agency treats it as a paper fight, briefs and scientific record, written submissions. And then the goal is kind of obvious, the get the rule quickly based on the written record and kind of dare your Bob Barr to challenge it later in federal court. It's a bet that no genuine dispute of material fact means no hearing needed. And so that it's a trade-off for speed now, litigation risk later. Moving on to the administrator override. Inside of the DEA, you have the administrative law judge. They're not the final boss. The DEA administrator is. The ALJ makes finding and recommendations, but the administrator has the final decision authority for the agency. So the move is this: if the ALJ issues a stay, slows the case down, tees up a long hearing, the administrator could step in, vacate the stay, take control of the file, and push the rule forward. That sounds kind of dramatic, and sure it is for administrative rules, but it's not a magic trick. If the administrator kind of like pushes through, steamrolls, whatever the process without a solid record and a defensible explanation, a federal court could stay that order later or vacate the rule. And so the bottom line, the agency's override button for speed, sure, there's a trade-off that shortcut might become litigation that you lose in the future. After that, the DOJ could say like, well, there's this case from the Supreme Court, 1973. Uh, Interestingly enough, that's also when they delegated their authority to the DEA. But they could say that the word hearing in the statute doesn't necessarily mean that. It could mean paper briefs only. And this is a case from the US v. Florida East Coast Railway, but it's 53 years old. And there's differences in this. And so like this hearing in a statute, paper briefs, that's agency interpretation. The traditional Administrative Procedures Act, not the express text of the Controlled Substances Act. And in the express text of the Controlled Substances Act, it says rules of the Attorney General in this section shall be made on the record after opportunity for hearing pursuant to rulemaking procedures. And then they point to the rulemaking procedures. So it's in the text itself expressly in the plain text. And so this formal rulemaking is not mandatory trial and cross-examination. The case about the railway loophole, this statute isn't vague like in that case where the statute was vague, but gets worse for trying to steamroll the hearing and just move forward with the rule because later, 50 years after that case, they overturned the Chevron doctrine. And the Chevron doctrine was deference to what the administrative agency's interpretation of the law was. And this is in the black letter, actually, of 21 USC 811. And as a result, the reviewing court doesn't have to give deference to what the DEA believes it needed to do. Canceled, it doesn't mean heard. Can they cancel it? Absolutely, they can. They could try to run this through by Friday. I would be very shocked if they do it by Friday. We'll see. They've already began the hearing. They adjourned it to do an interlocutory appeal. They had set the people that were going to speak and the witnesses and all that. Sure, there are a lot of, like Sam, for example, a lot of witnesses that do not support rescheduling. But doesn't it make sense to allow them an opportunity to be heard on the record? They're the ones that are going to say that their due process rights were violated if you don't give them that ability, because they're the ones who are going to lose with rescheduling. If you reschedule it, you block their objections. How long is this going to take? Well, since we last did this, nothing's happened. In the 2 months since Donald Trump issued his executive order to reschedule as expeditiously as possible, nothing's happened. Here's our effective date, maybe mid-2027. We gotta resolve this interlocutory appeal. That could be done, I think, the fastest because it's just an interlocutory appeal. And an interlocutory appeal, who does it go up to? It's not like a real appeal. It's similar, but you're not in court. Who do you appeal to? You appeal to the administrator, and so, like, the DEA head. and then it kicks back down to the ALJ. And who does the ALJ report to? The DEA head. So, like, if the DEA is really on board and they support rescheduling, they could be like, we don't need to have this appeal, but sit down over there, give the ALJ all the process that is due so he could write his report. I don't even know if they have an ALJ judge anymore at the DEA. They'll have to sit one of those. That might take a little bit more time, and then have that hearing on the merits, have the ALJ prepare his report, issue that to the DEA, and then the DEA could publish the final rule, and then you just have the CRA. That's like superfluous. It's an appendix. It's technically there. I don't think anything's going to happen on it. Remember, we do have an election before that December 26th right there. We'll see where the procedure is by then. Right now, we don't have any new news to report. The litigation is in the future. You don't just take $300,000 and not sue. But what will happen? Stay tuned to Cannabis Legalization News. That's right. We'll be here on Sundays. And hopefully we have like actual news one day. If you want to help us out, don't forget to click like, hit subscribe, and stay tuned to this next video that's going to be starting right now.